In the very real, very high-stakes world of California employment law, this gold bar logic, or gold truffle logic, is currently being fought out in a courtroom. Welcome to the latest update in Lively versus Wayfarer, a case that is currently sending ripples through the legal community and making every independent contractor in the state sweat just a little bit. If you thought employment law was just about HR handbooks and awkward, mandatory fun office parties, buckle up. We're diving into a legal battle that asks a terrifying question. Can you be held responsible for someone else's bad behavior just because you did business with them? At the center of this storm is an entity called the Agency Group, or TAG for short. TAG isn't a tech giant, and they aren't a traditional employer in this context. They're a public relations firm. Their job is to make people look good, manage the press, and handle the vibe of a brand. Wayfarer Studios hired them to do just that. However, the plaintiff, Lively, isn't just suing Wayfarer. They've set their sights on TAG as well. The accusation? Aiding and abetting retaliation. Under California's Fair Employment and Housing Act, FEHA, most people assume the rules only apply to the person signing your paycheck. But there's a sneaky little clause about aiding and abetting that Lively is trying to use as a legal lasso to pull TAG into the line of fire. TAG, understandably, is not having it. They've filed a renewed motion for summary judgment, MSJ, which is basically the legal way of saying, Judge, why are we even here? We're the PR people, not the hiring managers. TAG's argument is simple. FEHA was designed for the workplace. It was meant to regulate the relationship between the person doing the work and the person calling the shots. By dragging a third-party PR firm into a retaliation claim, TAG argues that the plaintiff is trying to turn a specialized law into a catch-all for anyone who was even in the room when a decision was made. In law, being in the room can sometimes be enough to get you in trouble. Does TAG have a point, or are they trying to dodge accountability for a situation they helped fuel? To understand why this is such a nail-biter, we have to look at the ghosts of cases past that are haunting this courtroom. TAG isn't just saying it wasn't us. They are carefully distinguishing themselves from other companies that did get caught in the FEHA net. Costco hired a third-party vendor called Rehab West to handle employee accommodations. Because Rehab West was literally stepping into the shoes of the employer and making decisions about which employees got what help, the court said, yeah, you're part of this. TAG's defense is brilliant in its simplicity. We aren't Costco's medical vendor, and we aren't Workday's algorithm. We're the people who write the press releases. We don't hire, we don't fire, and we definitely don't manage employee benefits. They're arguing that their relationship with Wayfarer was that of a service provider, not an agent of employment. If the judge decides that a PR firm can be held liable for an employer's retaliation, it opens the floodgates. Could your office cleaning service be sued if they aided a firing by clearing out a desk? Could the catering company be liable? The legal community is watching because if TAG loses this motion, the definition of who is involved in a workplace dispute is about to get a whole lot wider. Legal experts love a good analogy, and the one presented in this video is a masterclass in Explain It Like I'm 5. Imagine an employer hires Company G to manufacture 50 massive gold bars. The employer tells Company G to engrave the names of specific employees on those bars. Company G does the work, delivers the gold, and leaves. Then the employer takes those gold bars and hands them out, but only to the male employees, while the female employees get nothing. The employer has clearly discriminated. But did Company G? Lively's side might argue that Company G knew what names were being put on the bars and should have realized the distribution was unfair. TAG's side argues that Company G is just a manufacturer. They provided a product. What the employer does with that product is on the employer's soul, not the manufacturer's. This brings us to a public policy crossroads. If we start holding the gold bar makers of the world liable, does that make society fairer, or does it just make it impossible to run a business? Judge Lyman, the presiding judge, is now tasked with deciding if TAG was a gold bar maker, or if they were the ones whispering in the employer's ear, telling them who should get the gold. It's a fine line, as the video says. And depending on which way the judge leans, the entire structure of California business partnerships could be looking at a seismic shift. If TAG is kept in the trial, they are facing a messy, expensive, and public battle. If they are let off the hook, Lively's case against Wayfarer becomes a much lonelier fight. But what happens to the trial if the judge says, "Tag, you're free to go"? If Tag wins this renewed MSJ, the case doesn't disappear. It just gets leaner and meaner. We would be left with only two main pillars: a contract claim and the California FIHA retaliation claim against the primary employer. This trimming of the fat is a common strategy in big litigation. You throw everything at the wall at the start, and then the judge spends months peeling off the pieces that don't stick. But for Lively, losing Tag would be a significant blow. It's always harder to win a war when you lose one of the fronts you're fighting on. The opposition to Tag's motion is due in about a week. That means the lawyers are currently fueled by caffeine and spite, typing away to prove that Tag was more than just a bystander. They'll be looking for any smoking gun email or meeting note that suggests Tag didn't just provide a service, but actually encouraged or facilitated the alleged retaliation. As it stands, the expert opinion in the video suggests Tag has a very strong chance of prevailing. Judge Lyman likely won't want to be the one to create new law in California by expanding liability to third parties that don't do HR work. Judges generally like to stick to the path already paved, and Tag's path looks a lot more like a traditional business service than a co-employer. Legal battles like Lively versus Wayfarer might seem like they only matter to people in suits, but they actually define the rules for all of us. Whether you're a freelancer, a small business owner, or an employee at a giant studio, the gold bar rule affects how you interact with the people you work for. What do you think? Join the conversation below. Have you ever felt caught in the middle of a workplace dispute that wasn't yours? Do you think the gold bar analogy is fair, or is it missing the point? Drop a comment with your thoughts.